Data protection and compliance with GDPR regulations are critical aspects of modern business operations. But what exactly is GDPR and why does it matter? The General Data Protection Regulation, or GDPR, is a comprehensive EU law governing data protection and data privacy. It sets out the requirements for how organisations handle personal data. GDPR aims to enhance the rights of individuals whose data is held and give them more control over their personal information and prevent the misuse of information. Under GDPR, the individuals whose data is being held are known as data subjects. If your organisation holds or processes the personal data of EU residents, you're very likely to be subject to data protection legislation, regardless of your company's location. For example, a US-based company processing the personal data of an EU resident would be subject to the legislation. Non-compliance can result in significant fines. For example, a breach of GDPR can result in a fine of up to 4% of your company's annual turnover. GDPR introduces the concept of controllers and processors. A controller makes decisions about processing activities. They exercise overall control of the personal data being processed and are ultimately responsible for the processing. Processors act on behalf of the relevant controller and under their authority. In doing so, they serve the controller's interests rather than their own. It's important to understand whether you're a controller or a processor because that dictates the nature of your obligations under the GDPR. Controllers have more obligations than processors because they decide what personal data is collected and why, and exercise ultimate control over the data. As a controller, you're responsible for implementing appropriate technical and organisational measures to ensure your processing is carried out in line with the legislation. This includes implementing appropriate security measures to protect personal data and reporting a data breach to the appropriate authorities. Whilst processors have fewer obligations, they must be careful to only process personal data in line with the relevant controller's instructions. Whilst you might not think you're a controller, nearly every organisation is a controller because you probably store data about your employees. Most organisations will be both a controller and processor for different processing activities. You need to ensure that personal data is processed lawfully, fairly, and in a transparent manner. In GDPR terms, this means you must have a legitimate legal basis for processing personal data. The legitimate basis may be that the individual provided you with clear consent to process their personal data, or the processing of their data is necessary for a contract you have in place with them. The legislation clearly sets out the lawful basis for processing personal data. It's important that you have a lawful basis for processing personal data and have carefully considered what that is. Personal data is information that relates to an identified or identifiable individual, for example, a name, email address, or date of birth. It's worth noting that GDPR singles out some types of personal data as likely to be more sensitive and gives them extra protection. This includes data concerning health or personal data revealing racial or ethnic origin. If your company processes sensitive data of this sort, we always advise clients to obtain additional legal advice from a specialist in the specific type of sensitive data your company is handling. One of the key aspects of GDPR is that it gives data subjects specific rights over their personal data. For example, the data subject must be informed of how their personal data is going to be processed. You'll see this on websites, typically in the form of a privacy policy. You may also be aware that under GDPR, data subjects have the right to access a copy of the personal data you hold on them. This is typically known as a subject access request, and it's important that teams who communicate with your clients understand how to handle subject access requests. A common question we're asked is about how EU GDPR applies to the UK following Brexit. Since Brexit, the UK has adopted its own version of GDPR, known as the UK GDPR, which is largely based on the EU GDPR. UK GDPR forms part of the wider UK Data Protection Act. In June 2021, the UK approved adequacy, meaning that data can continue to flow as it did before in most circumstances. The UK GDPR legislation forms part of the UK's overarching Data Protection Act. Legislation similar to GDPR is starting to be adopted in many other countries across the world. Whilst there are differences, most are similar in their primary objective, which is to protect the privacy of personal data. So how can you determine what you need to do and whether you're complying? Adoptech provides an easy-to-follow step-by-step framework and automated tools that will simplify your compliance journey. If you're not sure about anything, specialists are on hand to answer your questions. Contact a member of the team for further information on what your organisation needs to do in order to protect individuals' rights, comply with GDPR and avoid costly fines.